Secretary and the chair, please come. What's happening?
Morning, honorable members and colleagues. The chair will be joining us very soon.
Okay, thanks.
Okay, all right.
Good morning, honorable members. Good morning to our officials and all stakeholders. Members, my humble apologies. I was a bit in transit, but I am able to speak. Can I have your indulgence, members, just to switch off my video due to the background where I am right now? But we can proceed. Mr. Mkiza, can you slide the agenda for us, please?
Permission granted, Chairperson, for your video to be off.
Thank you very much, Honorable Mananiso. Thank you very much, honorable members. Here is our agenda for today. Members, we note that we have the SA Express petition that we, as a committee, still have to go through and make sure that we compile a report that has covered all angles before we table it in the NCOP for adoption. I want to welcome the honorable members for joining us today for our meeting again on the 26th of May 2026. It's a Tuesday morning on the virtual platform. I want to also take this opportunity to welcome all the stakeholders and all the officials from Parliament who are also joining us, and everybody who is observing the meeting of the Public Petitions and Executive Undertakings Committee. Honorable members, can I have a input from Mr. Mkize regarding any apologies for those who are supposed to join us this morning? Mr. Mkize, is there any apologies?
Morning, Chair and honorable members. From the committee side, I haven't received any apology. The only apology from the stakeholders, it was from National Treasuries, Chair, that's all.
Thank you very much, honorable members, and thank you to Mr. Mkize for the input. We have a full house of the committee. Members, I just want to stress that I have received a communication from National Treasury. As you'll remember, in our previous meeting, we requested them to be part and to actually report on some of the issues that we have raised as this committee. Mr. Mkize, I just wanted to send that information to our members so that it must just also be noted that we have received that apology to all the emails of the members and on our WhatsApp group. All the members, without any move, this is now our agenda that we have. Can I have a mover for the adoption of the agenda?
We sent an apology.
Chairperson, Chair.
Please.
I can hear honorable
Employment and Labor. My hand is up, Chair.
Okay. Let him, Honorable Minister, can you allow the minister just to register? Honorable Minister, you can go. Is the Minister of Labor, Mayor Namakosa Zana-Meth. Over to you, ma'am.
Yes, Honorable Chairperson, thank you so much for the opportunity. Good morning to you and the honorable members on the call and all officials. I had forwarded an apology to request for early departure from the meeting because I'm attending the Cabinet Committee. That started at 10, but I'll join it late at 11. Now I hear it's not presented in the meeting. Thank you.
Thank you very much, Honorable Minister. Our committee secretary did mention, Mr. Mkize, that you've received an apology from your side to leave the meeting early. I just want to find out from the minister, is there somebody who will stand in your stead when we excuse you from the meeting? Any official who will be taking us through the...
Yes, Honorable Chair, I came here with the officials. They must indicate who they are, or maybe when I speak, after I hand over to them with your permission, because they are the ones who will be doing the presentation, I'll just do the overview. Then they will introduce themselves. Chair, thank you so much.
Member Mes, Minister of Labour, Employment and Labour. Honourable members, let us just go through then those apologies, but can I have a mover for the adoption of our agenda? Mr. Mkhize, can you fly the agenda again? All right. Thank you very much. Honorable Mananis, I think earlier on, I'm sure you wanted to move for the adoption of the agenda, noting also those apologies that we have received.
Thank you, Chairperson and honorable members on the call. I herewith move for the adoption of the agenda and as well apologies. Thank you.
Thank you very much, Honorable Mananiso. Can you have a seconder to the honorable members move?
Thank you very much, Honorable Chair. My name is Honorable Midupi Kim. I'm trying to put my video on, but you, Chair.
It's a struggle.
No. I got it. No, thank you very much, Honorable Chair. Before I second the latter speaker, I would like to raise a concern that maybe it will be proper next time that department should indicate to us the reason why we are receiving late reports. Thank you very much, and I second.
No, thank you very much, Honorable Midupi, for that. And I think maybe we'll also afford them the opportunity to take us through that. Honorable members, we have adopted now our agenda. And then we're going to proceed. The petition that we have received and the item that is before us, can you just write it, Mr. Mkhize, again? The agenda, I know that members received that email, I think, sometime last week, but some of the information was sent to us on email. We are dealing with the petition of the South African Express by the former employees who are still having concerns in terms of the compensation from the company. Now, in our previous meeting, we took a decision to involve all the relevant stakeholders to take this committee through so that we can satisfy ourselves that indeed, as the petitions committee, we have done due diligence. We have dealt with all matters that are before us. We took a resolution to get even a legal opinion from Parliament's legal services to guide the work of the committee. The committee further then requested that we do an internal analysis from our research unit that will also guide the work of the committee as we want to conclude this petition and deal with it as a matter of agency. We did, as a committee then, take a decision that we will further explore because we want to act within the best interests of the former employees of South African Express, noting the seriousness of this petition. And in that order, we have received a number of presentations, both from the Department of Labour, from Parliament, legal services, as well as an input from the pensions adjudicators administrator. Mr. Mkhize, I just want to guide us. Those key stakeholders, are they on the platform? And who will lead those presentations?
Yes, Chair, they are on the platform, Chair. But in terms of who the leading, I think they'll need to introduce themselves. But I wasn't informed who will be leading the presentations, Chair.
No, thank you very much, Mr. Mkhize. Indeed, we don't have a lineup. But noting what the Honorable Minister had indicated earlier on, Honorable members, with your indulgence, and I request that we deal with the Department of Labour to touch on this issue because it does have labour implications. And the Department of Employment and Labour is critical in this process so that we as a committee can satisfy ourselves that indeed, as a committee, we have gone through all avenues to deal with the petition on the SA Express. And now that we have the minister and who has indicated that she will be leaving us shortly, I will then ask maybe the Department of Employment and Labor start first, and then the minister will just do her opening remarks, and then she will take us through who will lead the presentations. Honorable Minister, are you ready with your team? I'm going to hand over to you.
Thank you so much, Honorable Chair. We are ready. And
Okay.
the administrative team is led by DDG Moila because the acting DG is writing exams. So I'll start with my overview, then with your permission, hand over to DDG Moila.
All right. Honorable members, I will then hand over to the minister if there are no objections. In the interest of time, let us allow the minister to do her opening remarks and then hand over to the official who will be doing that. I don't see any hand. I assume that members have given us a green light to proceed. And Member Med, I'm going to hand over the reins to you. Over to you. Thank you very much.
Thank you very much, Honorable Chairperson of the Select Committee on Public Petitions and Executive Undertakings. Honorable members of the Select Committee, the Acting Director General, officials of the department. I know acting today is DDG Moelwa, officials of the department and UIF, the people of South Africa who are observing the proceedings of the Select Committee, Chairperson, and honorable members. Allow me first to express my appreciation for the opportunity to appear before this important Select Committee. Parliament remains one of the most critical pillars of our democracy, and committees such as this one play an essential role in ensuring that government remains responsive, accountable, and attentive to the lived realities and grievances of our people. The work of the Select Committee on Public Petitions and Executive Undertakings speaks directly to the constitutional responsibility of the state to listen to citizens, to provide answers where there is uncertainty, and to ensure that no person feels abandoned by public institutions. It is therefore an honor for us as the Department of Employment and Labor to appear before you today to assist the committee in its consideration of this matter concerning the former employees of South African Express Airways. The Select Committee has requested the department to attend a hearing on a petition submitted by Mr. H.B. Kasibe. In your letter, Honorable Chairperson, you stated that the aim is to assist in responding to some of the queries and to make submissions that will help the Select Committee finalize the petition and provide the petitioner with the best relief possible. We shall try to assist the Select Committee to the best of our competences. Honorable Chairperson, the respect that I have for Parliament and its committees pushed me to come and start in this prestigious committee even before I go to attend the Cabinet Committee meeting. So indeed, I have an early departure apology as I have to join the Cabinet Committee that starts at 10:30 and I'll join it at 11. I have equally tendered my apology to the Cabinet Committee for my late arrival there because I considered it important that I first appear before this Select Committee and engage on this matter. Honorable Chairperson, we are appearing before you after you have had two other meetings already. One meeting was on the 4th of December 2025 and the second one was on the 24th February this year. In the first meeting, you had Minister of Transport, Minister Chrissy, and she appeared before you with an official from her department legal unit. Sequence of events that led to liquidation were outlined in that meeting. Our transport colleagues ended that meeting by suggesting that you consider inviting liquidators themselves in a next meeting, a suggestion that you took, and the meeting with the business rescue practitioners together with the liquidators was convened on the 24th of February. Both meetings, the first and the second, put before the Select Committee what they know had happened in South African Express Airways and why it had happened, as well as how. We are here to add, amplify, and of course, respond to your request. Among others, those meetings said The root cause that led to liquidation of the South African Express Airways were the unsound and irrational strategic decisions and operational errors. These were compounded by inefficiencies and lack of effective system of financial controls. Some of these included overstatements of profits in the previous financial years, lack of funds to pay legacy debt accumulated since the airline's establishment, alleged malfeasance in the awarding of contracts. Business review practitioners indicated that SA Express had been facing liquidity challenges for a very long time prior to being placed under business rescue. There were about 4 pending liquidation applications filed by other creditors to place SA Express under liquidation. The Select Committee was also informed that SA Express had deducted employee-related taxes, pay-as-you-earn and UIF, from employee salaries, but had not consistently remitted them to SARS for almost 18 months. Honorable Chairperson, we have invited the Department of Employment and Labour to respond on whether the former SA Express employees listed in the petition qualify to UIF payments and establish as to whether they were contributing to UIF. Needless to state that the correspondence package we received had no employee list. Nevertheless, our response is that Section 66 of the Unemployment Insurance Act grants rights to unemployment benefits to contributors whose reason for unemployment is the termination of contributor's contract of employment by the employer of that contributor or the ending of a fixed-term contract. The dismissal of the contributor is defined in terms of Section 186 of the Labour Relations Act 1995 as amended, or insolvency in terms of the provisions of the Insolvency Act 1936 as amended. Therefore, in this case, the employees are entitled to UIF benefits. SA Express was registered to UIF. The last declaration was for one employee in November 2021. The bulk termination was done in August 2020. The list of employees is provided in the presentation. It is from January 2008 to November 2021. The full report of declaration from year 1994 is maintained in the system. Now, when it comes to pension fund and provident fund related benefits, these are of course not administered by the Department of Employment and Labour, but at least we can provide the information that Section 37B of the Pension Fund Act savings are protected and regarded as the asset of the employee, but cannot be assessed immediately as they are payable once liquidation is completed. In conclusion, Honourable Chairperson, would like to share with the Select Committee recourse that is provided for in terms of some pieces of legislation that are there. Yes, some of these do not reside with the Department of Employment and Labour as it were, but there are laws of the country that could be further explored. For instance, Section 98A of the Insolvency Act of 1936 as amended classifies employees as preferent creditors and are therefore entitled to the residue regarding unpaid remuneration, wages or salaries for services rendered in the 3 months preceding to the insolvency. Section 16 of the Unemployment Insurance Act provides that for the entitlement of benefits for the contributors that have lost employment due to insolvency, and as such, the employees are entitled to apply for unemployment insurance benefits. Section 18 of the PCA regulates payment for holiday, and the employees are entitled to accrued holiday pay. Section 41 of the Basic Conditions of Employment Act of 1997, as amended, accords the employees a severance pay calculated as 1 week's salary for every year in continuous service. Section 37B of the Pension Fund Act provides the employees an entitlement to claim their pensions and provident fund benefits. Now, in the confines of our competences and also within the laws that govern us, this is our story, Chairperson, which is now going to be continued by the representative of the Acting Director General and the team that is here with us today. Thank you, Honourable Chairperson. If you allow, I'll request Titi Moelwa to do the presentation. Thank you so much for the opportunity.
Thank you very much, Honourable Minister. The appointed official who's going to take the committee through, the reins are over to you. Thank you very much, Honorable Minister, for those opening remarks.
Thank you, Chairperson, and also thank you to the Minister and the honorable members of the Select Committee. I trust that you can see my picture, Chairperson, and if you allow me, please let me switch off my video.
You are allowed, DG, and thank you for switching your video. We truly see that is the person behind the presentation. You can switch off, it's fine.
Thank you, Chair. And I just want to thank the Honorable Minister for laying such a solid foundation. I also want to take the opportunity to introduce the team from the department. On the call, we've got officials from the Compensation Fund that are led by Dr. Malebu Mabije Thompson, who is the acting commissioner. And I trust that when they get the opportunity, they'll then be able, the acting commissioner will then be able to introduce the rest of the team. From the Inspection Enforcement Services, we've got Advocate Msiza, who is going to be taking the committee through the presentation, which in its very nature, it is talking about the regulatory elements of the department. And Chair, I also want to indicate that further on the platform, we've got our communication team led by our Chief Communications Officer, Ntate Teboho Tejane. So through you, Chair, I'd like to hand over to Advocate Msiza, who's going to take us through the presentation regarding our regulatory environment. Thank you, Chair.
Thank you. We can proceed. Over to you, Advocate.
Good morning, Honorable Chairperson. Good morning, Honorable Minister. Good morning, Honorable members, the Inspector General, and all colleagues. Indeed, the presentation it's slated there, and the presentation is about our role as the Department of Employment and Labour in ensuring that we enforce in regard to this matter. And the first slide, it's about the legislation that we administer. And if you can see, Honorable Chair, is that the 80 to 90% of the work or the complaints fall squarely within the Department of Employment and Labour, except the part that talks to the insolvency, which is administered under the Master's Office, and also the part that deals with the Provident Fund and the pension funds, which are administered separately from those jurisdictions under the enabling legislation. But all what is said here, without waste of time, it's a list of the piece of legislation that we administer as the Department of Employment and Labour. And those pieces of legislation are talking to a healthy working environment, social security, social justice in terms of PCA, National Minimum Wage and Labour Relations Act, and ensuring that the employees are protected under employment equity in terms of redressing the imbalances of the past. That's what we administer as the department. And slide number 3 there talks to the different purposes of the legislation that I've summarized. So without wasting time for Parliament, I would move to slide number 8, if it can be flighted as such by those that are controlling the slides. Yeah, if you look at slide number 8, we are then responding to say the Select Committee has received a petition from SA Express. The petition having considered the challenges that were there before the Select Committee and the second House of Parliament, or the NCOP, and the background is given very clearly on slide number 9. In terms of slide number 10 there, we then respond to say what is it that has happened. If you look at slide number 11, Chairperson, it gives a background in terms of what has happened to say, indeed, the South African Express faced liquidation in November 2020 after numerous issues that pertain to provisionals, liquidation, and also the attempt to rescue the company by business rescuers, and that attempt did not work. And as such, on the 13th of February 2020, it had entered that business rescue, which resulted in November 2020 in a liquidation by the selling of assets of the company. And therefore, what it meant is that In terms of slide number 13, is that the Insolvency Act was applied, which then classified the employees as preferent creditors. What does that mean? Is that once you face liquidation, there is a classification of employees as secured creditors, preferent creditors, and concurrent creditors. Secured creditors would mean your banks that will then get the first light in terms of the residue, which will come from the whatever that is sold for the company. And employees will then enjoy the second category, which is the preferent creditors category, and the rest of the creditors will then enjoy the concurrent creditors category. In that way, the law was trying to secure the employees for a second category so that at least they can also benefit and not be left out in the cold when the liquidation is done. And the law is very clear to say what is it that will have to be taken into consideration. It's a question of unpaid remuneration, wages, salaries, and services that rendered between 3 months preceding the insolvency, and that there are contributions for unemployment insurance, medical aid, provident fund, and any other benefit funds should also be secured 3 months prior to the insolvency, and that whatever that statutorily has been accrued, be it a holiday pay, be it leave, be it whatever that has to be secured, like a severance pay, has to be paid accordingly. That's where then we come in as the department to make sure that all those protections accorded to them are practicalized. And therefore, in terms of Section 37B of the Pensions Funds Act, those savings are protected, like the minister has said, it's a protected asset, but can only be claimed once the liquidation has been finalized. And we take it that the liquidation has been finalized because it dates to 2020, even though we do not have a date on which it was actually finalized. But all what we can then say, in essence, when we come to the last slide, is that what is it that will do as the Department of Employment and Labour? We accept that the section on slide number 18, which is the last slide, so that we don't waste the time of Parliament, is that the Insolvency Act is very clear to say they are classified as such, and which means that from what has been secured in terms of the residue of the company, the creditors, or what you call liquidators in an ordinary language, should have made sure that also the employees benefited from such. And what we'll then have to check is whether the employees benefited from such or not. That's something that we'll have to check as the department. And secondly, yes, we accept to say the employees are entitled to unemployment insurance benefits, and in terms of Section 16 of the UI Act, and they can apply for such. If there's an employee that has not applied for unemployment insurance benefit, such an employee must be accorded an opportunity to apply for unemployment insurance benefits. And then also we accept that they were supposed to get something in terms of a severance pay, which is calculated at a minimum on 1 week's salary for every and continuous service, and we'll have to check if all employees of South African Express got the severance pay. If they didn't, then we need to then open a case and make sure that we issue a compliance order in that regard against the creditors or against whoever that has still there, if the creditors are still there. And secondly, to check in terms of the pension fund whether whatever that was deducted from them and was also payable to the pension fund, was it paid accordingly. And we have Section 34 A of the Basic Conditions of Employment Act to ensure that we also enforce as such. In that regard, the pension funds will have then to come to the board in terms of making sure that everybody has got an opportunity to apply for pension funds benefits, and if such applications are received, they have got to be adjudicated in accordance with the law, and to make sure that these employees do not suffer secondary unnecessary pressure in terms of the liquidation itself. So in that regard, I would say that we still have a role to play to check if all those provisions of the law are complied with. And indeed, if they were complied with, then we'll say that the matter was correctly handled without getting into the nitty-gritties of the liquidation itself, because that is outside our mandate. But our mandate is to make sure that whatever that flows as a consequence of the liquidation, the employees don't suffer adverse consequences. That's what they will have to check and make sure that it happens from here. Thank you so much. I think we have given our position to say as the Inspection Enforcement Services of the Department of Employment and Labour. What is it that we will do to make sure that there is full compliance in that regard? Thank you so much.
Through you, Chair.
No,
Thanks. Thank you. I thought we'll then, yes, thank you, Chair. I thought we'll then, from the administration point of view, we'll then afford the Unemployment Insurance Fund an opportunity to speak to matters around this. And I'll hand over to the Acting Commissioner. Thank you, Chair.
They can proceed. Thank you, Ma'am Ilwa.
Thank you very much, IG. And good morning to the Honourable Minister, Honourable Chair, Honourable members. We will then be taking you through 3 of the questions that you had put to the fund in relation to the membership of or whether this company did contribute to the fund, about payment of benefits, and where all of that stands. I'm going to ask our CIO to do that. But before I do that, I'll start by introducing myself. My name is Dr. Malebo Mabije Thompson, Acting Commissioner of the UIF. And on the platform, we've got our Head of Corporate Services, Mr. Matabela. We've got our Chief Operations Officer, Ms. Mutibedi. And then we've got our CIO, who would then introduce himself as he takes us through 3 of our slides on this matter. CIO, over to you.
Thank you. It's always good. It's standard procedure, Mema Thompson, that we just show our face. I know that this morning I'm not leading by example, but members also just want to appreciate who are the officials, and then we grant permission. If you're having challenges with your network or your data, then you can switch off your video. Thank you. We see you. We can proceed to Mr. Naheem Esop, as you have indicated.
No, CIO of the UIF. Thank you, Chairperson, and apologies for that.
Noted.
Good morning, Chair. Good morning, Honourable Minister, Honourable members, as well as the IG and the colleagues from the department. My name is Raymond Makuya. I'm the CIO of the Unemployment Insurance Fund. Chairperson, with your permission, can I disable my camera with the proof of life so that I can maximize my bandwidth?
Not a problem, is granted. And all officials who are also on the platform, if you're not speaking, you can just switch off your video so that we focus on the presentation and the official who's leading the video. So any other person, switch off your video, and then we're going to hand over to Mr. Makwaya, who's going to take us through. I just want to register one concern. The presentation, we received it late. And I know that the minister is not now with us. Members have raised concern because standard procedure is that we receive at least 48 hours before the meeting, so the members can go through and the committee can satisfy themselves with the contents of the report or presentation. I've been informed this presentation only reached our office yesterday evening, and that is not acceptable. We cannot, as Parliament, be treated in this manner. This committee must be respected, and these members who are on the platform must be respected, that they must satisfy themselves with the contents. It does not assist us, as Honourable Midupi said earlier on, and we take great exception to that. When a committee invites you, it is important that we give you a date and a time. Reports and presentations must reach us at least, if you are late, 48 hours before the meeting. And with those concerns, I hope that will improve in future. It cannot be tolerated. You can proceed, Mr. Makwaya.
Thank you, Chairperson, and duly noted. I'm not so sure. I see the hand of the minister, or should I proceed, Chair?
From my side, I don't see any hand,
Okay.
Mr. Makwaya. I don't see any
Thanks.
hand from my side.
I've lowered
You can
it,
proceed.
Chairperson. I had
All
my
right.
hand up. I've lowered
All right.
it, because I wanted to profusely apologize. I even hear my officials say duly noted. It's not enough. We should present an apology. We owe an apology to the Civic Committee for having done that. I'll investigate what had happened. Apologies, Honorable Chair.
We'll take note of your apology, Minister, and thank you for that. And thank you for showing leadership in your department. From my side, I really appreciate that. You can proceed, Richard Makwaya.
I thank you, Honorable Chair, and thank you, Honorable Minister. Chair, on slide number 18, we just wanted to confirm, as per the ask of the committee, that we confirm that the company is indeed registered with the Unemployment Insurance Fund. Yes, we can confirm that they are in our database as a registered employer. The last date or month of declaration, as the minister alluded, is the month of November 2021. That's when they last did a declaration with the one employee. In the next slide, on slide number 19, we are giving a breakdown on a monthly basis of the declarations insofar as the number of employees that were submitted by the employer. We limited it due to space to the last 13 years from 2021 up until year 2008 on a monthly basis, where we were alluding to how many employees were that. I am not so sure who's sharing. If they can just share the slide on behalf for the benefit of the committee. On slide number 19, that's where we are alluding to the number of employees, and you would then see that on slide number 13, in the month of August 2020, there were 455 employees that were then reduced to 3 in the following month of September. That is the breakdown insofar as that, and we have done that in a tabular format to at least give the committee the benefit that indeed those are the numbers that we were receiving insofar as the contributions from the employer side. Chairperson, on slide number 20, we are giving you a slight background with regard to the claims that were submitted by the employees of this particular company. According to our records, because we limited it to this particular company. In the lifespan of this company, meaning in the records of the system, we've got 1,389 claims that were approved and paid. That's from 1994 up until 2021. Those are the number of claims. But in the year 2020, which is around the liquidation period, because that would be the time that a lot of terminations were then happening. Then we've got around 525 employees that came in and claimed, and these claims were then approved and subsequently paid to the individuals. We must also highlight to the committee that this company as well, during the pandemic COVID-19, also made a application which was duly approved and paid to the employer in that particular period. I will thank you, Chairperson, and pause here with my report. Thank you, Chair.
Thank you very much to you, Ntate Makwaya. I'm not sure, is there any other inputs from the employment, the labor, and its entities?
That is all from our side, Chair. I thank you.
Thank you very much for that. I see the hand of Honorable Nonkonyane. Nkosi, over to you, the committee whip.
I think first of all, I did indicate to the Secretariat that they must send this notice to my laptop, to my email, so that I can be proper. They have not done so. I don't know why. I also sent some note chat in the chat box to request that, but that is water under the bridge. Secondly, to thank the minister for apologizing, because I was embarrassed that we receive this presentation only after 9:30 this morning. Therefore, we were not given as parties any opportunity to confer amongst ourselves so that we can really assist in the process. But anyway, I think the apology of the minister is really what caused me to come down and thank him for that leadership. Two things, maybe three, that I would like to raise while the minister is still with us. One, this, I believe, was one of the state-owned enterprises. And I know then that the state-owned enterprises, the shareholders were the ministers. In other words, the government was the major shareholder. Now that we did receive here that for quite some time there was a reckless trading, as it were. In other words, it continued to trade under insolvent circumstances for quite some time. And I know that in terms of the law, therefore, the shareholders, particularly the directors, may be personally liable for any costs. Just to find out from the ministry's side whether they were part of the directorate, and if so, whether they were aware that this entity traded in insolvent circumstances for quite some time, which led to this petitioner submitting this. And then from the administration side, I also know that in terms of the law that they've cited, cited the legislation, there are inspectors. Whether the inspectors did conduct their duties in terms of the act in the years in question, and whether there were any findings, and if there were no findings, was there no recklessness on the part of the officials of the department itself when they were conducting inspection in respect of these entities, then I think then I agree with them that, of course, as the minister correctly tied up as well, mentioned, is that the employees are actually one of the preferred creditors in terms of the solvency law, and whether the data assisted in making sure that once that entity was liquidated and the employees were assisted in one way or other. I'm aware of what they are doing in terms of the UIF, and I have no qualms about it. But I would love if there's any clarity around those two questions from the administration. Otherwise, thank you, Chair, and thank you for. Thank you.
No, thank you very much, Honorable Nonkanyana, for those inputs. I'm going to do this, honorable members, so that we engage all presentations at once. It will maybe assist us. Now that you've gotten the input from employment and labor, and it is a comprehensive input that members is contained in the presentations, coming from the department itself, as well as one of its entities, the UIF, and I think it gives us a clear light in terms of what transpired with SA Express. And what is also important is that the department, as well as its entity, it has the records. And you'd see members that even the numbers are corresponding to what we gotten from the from the petitioner. Now, in terms of proceeding, I'm going to request members that we go through the second presentations, note your concerns, note questions that you want to address to labor, note your question that you want to address to its entity, and then we'll take the next stakeholder so that we have a comprehensive and a clear picture of what is transpiring, getting the feedback from the stakeholders. With your indulgence, members can just get a green light from any member in terms of the way forward.
In order, Chair, we can continue.
Thank you very much, honorable members. Mr. Mkize, I would like us to go through with the pensions adjudicators administrator. I believe they're also on the platform. They must just introduce themselves, who's leading the delegation, and then they
Chair,
can fly.
Chair.
Just hold, I will assist you now, Honorable Mkosi. I will come now to you. And then you will just tell us who is on the platform as well. Honorable Nonkonyana, what is the point?
No, I'd raised my hand before Honorable Mananeso agreeing with you. I did request that before the minister leaves, if she can actually clarify. And if she's not able to clarify now, to follow up later on, I would have no problem. Subject to that, I don't have a problem with the administrators responding to my questions later. That was the only thing that I wanted just to raise, because the minister did indicate that at 11 she must be excused, and I think we had agreed with her that he needed to be excused because he did respect us, indeed, by coming.
No, thank you, Honorable Nkosi, for that. Indeed, the minister has requested to be excused to join cabinet, the cabinet committees. She has also indicated that she is having a delegation from her department who are here with us, and she's also taking leadership for all matters that are before our committee. And you want to express that appreciation to the minister. I know that she will be excused at 11 o'clock. And her department, I'm sure they will be able to take the committee through the concerns that we'll have. Without wasting any time, can we get the pensions administrator for us? If they're on the platform, Mr. Mkizo, you must just indicate to me. I'm looking at the screen and the hands. Is it Mr. Nahim Esop?
Good morning, Honorable Chair, honorable members and officials. I'm Nahim Isop. I'm the Deputy Pension Funds Adjudicator. I'm standing instead of the Pension Funds Adjudicator, Mr. Lebogang Mogashwa, who's involved in a prior engagement, but he has advised that as soon as that engagement is dealt with, then he will join us.
Okay, thank you for that. We really appreciate that. Mr. Mkizo, just from your side, I don't know who's handling the presentation. Can the presentations from the pensions educators be also flighted for members? I know that you've sent it, but as we are going through this session, we wanted to flight the presentation on the screen. And then you can sit, Mr. Naim Esop. Thank you.
Yes, noted, Chair. I have made Mr. Esop co-host so he can flight the presentation on his side.
All right. Can you please indicate if you can see this presentation?
Your presentation is visible, sir.
Mr. Rahim, you can proceed. We can see your presentation. Just if it's possible to put in presentation form or slide show so that we don't see any other parts of your computer, but just the document itself or the presentation. But you are granted, you can proceed. And if you're having challenges with your video or your network, you are welcome to switch your video off.
Thank you, Chair. Chair, so we prepared a short presentation. I'm aware that our presentation was also submitted late, and I would like to offer our apologies to the committee. We will certainly ensure that it doesn't happen in the future again. Chair, let me just get into it. We were provided with the summary report of the hearings that were held on the 4th of December and the 24th of February earlier this year. And we provided a presentation that deals with our mandate and our jurisdiction, and then some guidance on how complaints can be lodged. And we deal specifically with the issues that were raised in the hearings and propose a way forward at the end. Chair, the Office of the Pension Funds Adjudicator is established in terms of Chapter VA of the Pension Funds Act. It investigates pension fund related complaints, and it issues determinations and orders that may be enforced in the same manner as a High Court order. The mandate of the Office of the Pension Funds Adjudicator is to dispose of complaints in a procedurally fair, economical, and expeditious manner, taking into account the provisions of the law, contractual arrangements, legal relationships, and where appropriate, we apply principles of equity. We do have limited jurisdiction, and one of the issues that...
Honorable Member, Mr. Naim, can you just give us a moment?
Yes.
Who's
It's
Member
Honorable
Manani,
Manani, so I just wanted to indicate that the slides are not moving.
Oh, no, thank you very much. I saw that. Mr. Naim, as you move, I'm sure you've got somebody who's going to assist you to move the slides. Otherwise, you can send the presentation to Mr. Mkize, who will assist you to move the slides. So as you speak, the slides are also moving in that order. Are you able to do it from your side, Mr. Esop?
Yes, Chair, it is moving on my side. I'm not sure why it wouldn't be showing up on your side, but the slides were sent through. I'm not sure if they can present it on
We are still
side.
on slide number 1. All right. Mr. Mkize, can you just assist there? Move also with the presenter so that we can follow in that order. On what slide are you on, Mr. Esop?
We are on slide number 4, or number 5. Number 5.
Number 5. All right. You will just guide our official as you move for the presentation. Over to you.
Thank you.
You can proceed.
Okay. I'm just waiting for the slide to come up. Slide number 5, please. Thank you, Chair. So, Chair, our jurisdiction is limited, and that we cannot investigate complaints that are older than 3 years. Those complaints are considered as time-barred. However, the calculation of the 3 years is with cross-reference to the Prescription Act. So things like when did the complainant would have had knowledge of the issues giving rise to the complaint, or matters pertaining to age of majority, etc. All of those things come into play when we are calculating the 3-year period in terms of time barring. We also don't have jurisdiction if there are proceedings that have already been instituted in a civil court before the lodging of the complaint. In that case, the proceedings before court will take precedence. We also, in terms of our jurisdiction, complaints are defined in terms of the Act, and it must relate to one of 3 things, which is the administration of a fund, the interpretation and application of fund rules, or the investment of funds. And if it does not tick one of those boxes, then we cannot investigate the matter. Where a fund is in liquidation, that also ousts our jurisdiction. It's a process that is dealt with by the FSCA. Please note, Chair, that this is speaking to when the fund is in liquidation, not the employer, as is the case in the current matter. And then we also only have jurisdiction in respect of pension funds that have been registered in terms of the Pension Funds Act. So complaints relating to the GEPF, Transnet Pension Fund, Post Office Pension Fund, etc., do not currently fall under our jurisdiction. Chair, then how to lodge a complaint? We receive complaints in writing. We do have a complaint form, and these can be delivered to us at our offices, or it can be submitted online via email, post, or fax. And before lodging a complaint, complainants are required to address the issue with their pension fund. And if they do approach our offices before that, then we do facilitate that through our RTF process, and we allow the fund an opportunity to try and resolve the complaint within 30 days. Chair, then the types of complaints that that are lodged with us, you'll see on the slide, there's a whole list. I'm not going to go through all of them. But the issues relating to the non-payment of contributions or where there are benefits held by a pension fund that hasn't been paid, we do deal with those type of complaints. And I noted that in the summary that there was issues relating to that. Then in respect of this particular matter, we did not find any complaints that were lodged with our office by the employees or former employees of SAX. In terms of jurisdiction, we are not aware of which fund they were participating in, but if they do lodge a complaint with our office, then it must be a fund that is registered under the Pension Funds Act. Time barring may apply, but it won't be applicable to an unclaimed or unpaid benefits where the fund acknowledges that it holds a claim on behalf of the complainant. UIF contributions and benefits do not fall within the definition of complaint as defined, and these should be referred to the Department of Employment and Labor. As with the audit into number of employees prior to liquidation, employees who receive benefits after its liquidation, other than pension fund benefits, and assets held by SAX before its liquidation, those all do not fall within our jurisdiction or within our expertise. And these may be referred to the Department of Employment and Labor or to the liquidators. We may investigate non-payment of pension fund contribution by the employer and payment of pension benefits by the fund, provided that we do have jurisdiction, it's not time barred, and there's no other proceedings with the same subject matter before a civil court. On the way forward, Chair, I see a hand. I'm not sure if you would like me to stop.
Thank you very much, Mr. Esop. The hand is from Honorable Gerika. Honorable Gerika, what is the point?
No, Chair, good morning to you and the colleagues. It's fine. I will wait until Mr. Esop has concluded. Thank you.
Thank you very much, Honorable Gerika. You can proceed, Mr. Esop.
Thank you, Honorable Chair. So, Chair, the issues relating to UIF is a matter that we cannot deal with. So we are proposing that it be referred to the Department of Employment and Labor. And the issues relating to the audit into the number of SAX employees prior to liquidation, employees who receive benefits after its liquidation, other than pension fund benefits and assets held by SAX before its liquidation, those we are proposing to be dealt with by the Department of Employment and Labor and or the liquidators. We would then have to determine which fund the SAX participated in and whether it is registered in terms of the Pension Funds Act. And if so, then the employees may lodge complaints with our office. They will have to provide us with the relevant information, completed claim forms, ID documents, payslips, proof of fund membership, etc. We will then determine jurisdiction in terms of time barring and whether it is before another court. And then if we are satisfied on jurisdiction, we will then commence our investigation. Thank you, Chair.
No, thank you very much, Mr. Naim Esop. Honorable Gerika, I don't know, is the legacy hand, but I see your hand is still up.
No, Chair, it's a new hand. Can I proceed?
You can proceed. What is the point?
Yeah, the point is on the presentation of Mr. Esop, whereby he said that if the claim is older than 3 years, he basically implied that the claim then expires, if I understand him correctly. Can I just get clarity so that I don't waste time?
Okay, what we'll do, honorable members, I indicated earlier on, we just go through the presentations and then we'll engage with them. We have taken the decision. We just have 2 more presentations to go, and then we'll engage with the stakeholders. All stakeholders are still on the platform, and they will be able to engage members when we open that floor.
That's fine, thanks.
Okay. Thank you very much, Honorable Member. Namaste Isop, thank you very much for your presentation. Thank you for your input. Members definitely have got some issues that we need to engage with you. Honorable members, you would know that, as I indicated, we have 2 more presentations to go. These ones are more internal, coming from our legal unit. We asked them to give us an opinion in terms of this petition. We also requested our research unit in Parliament to give us an in-depth analysis of this petition. You will see that as this committee, we take this petition very serious and want to reach the bottom of it. We want to make sure that all avenues are explored. And then without waste of time, Mr. Mkize, can you just indicate to me, do we have a representative from Parliament, from the Legal Services Unit? I want to give...
Yes, we do, Chair. Yes,
all
we
right.
do.
All right.
Yes.
Can you just make sure that the official introduce herself or himself? I see there's A. Arnold from Parliament. I'm going to hand over to you, and then you must just flight that presentation for us. Thank you very much.
Good morning, Honourable Chairperson, and good morning, Honourable Members and all colleagues on the platform. My name is Adla Arnold, and I am from Parliamentary Legal Services. Chair, Honourable Members, I haven't prepared a presentation. What I have prepared is a legal opinion as well as comments on the draft report which I received from the Secretariat of the Committee. Chair, I would request that the Secretariat share the legal opinion as well as our comments on the draft report with the committee. But I will go through, I will brief the committee on our legal opinion. Chair, Honourable Members, our office was requested...
May Arnold, just hold on quickly.
My
Can
apologies,
you fly
Chair.
that? Yeah. Can you just fly that? It will be nice to, as you present, you go through it. Mr. Mkize, can you just put that report for us on the screen? And then Ms. Arnold will go through it with us.
Chair, if the Secretariat can first flight the recommendations and scroll down to paragraph 7. And I would like to speak to the recommendations first, and thereafter they can flight the legal opinion, please.
Yes.
In that order is granted. In that order.
Yes, I've made you a co-host. You can, yes. On your side, I've made you a co-host.
Oh, should I flight it? Okay, I'll do so.
Yeah, you should flight it, yes. Okay, sure.
Chair, I'm uncertain if it is showing.
From our side, we can see it.
Okay. Thank you, Chair. Thank you, Honourable Members. So our office was requested to prepare a legal opinion on SAX, South African Express, and we were specifically requested to opine on whether National Treasury and the Pension Fund Adjudicator are both empowered to investigate on behalf of the committee and to brief the committee on the extent to proceed with formulating informed recommendations at this stage without going beyond the mandate and legal framework of the committee, and whether some of the recommendations in the attached report are proper to be part of the draft report. So, Chair, Honourable Members, colleagues, before you is the recommendations or other recommendations contained in the draft report. These recommendations are contained at paragraph 7. And it's recommended, it is against the observations and key findings made by the committee that it recommends as follows. 7.1, the National Treasury and the Office of the Pension Funds Adjudicator are to spearhead an urgent investigation into the issues raised in the petition. This investigation, 7.2, this investigation is to include all the affected stakeholders, i.e. the Department of Labour, the Department of Transport, to determine if the former SAX employees listed in the petition qualify for UIF payments and establish whether they were contributing towards UIF. Paragraph 7.3, the investigation is to further entail, inter alia, an audit into the number of employees SAX had before its liquidation, the number of SAX employees who received benefits after its liquidation, and the assets held by SAX before its liquidation. The Office of the Pension Funds Adjudicator is to investigate the non-payment of pension and provident-related benefits to the petitioners. The joint liquidators provide, paragraph 7.5, the joint liquidators provide evidence of the unclaimed benefit funds and to provide a written report to the committee on what happened to the proceeds of the assets that it was able to recover and dispose of following the liquidation. 7.6, the investigation is to be completed within 6 months of the adoption of this report by the House. And paragraph 7.7, following the completion of the investigation, the affected stakeholders are to appear before the committee and report on the outcomes of the investigation as well as propose a way forward. Chair, we had then drafted a legal opinion in respect of those recommendations. Chair, honourable members, and from our research, we note that the committee had met on the 4th of December and the 4th of February 2026 to consider the petition. In our view, the main issues that we have identified include the following. Number one, the perceived disparity in status support. This relates to the perceived difference between the treatment of South African Airways, which was bailed out, and SAX, which was then placed into liquidation. Number two, another issue which is pertinent.
Ms. Androld, my apologies, sincere apologies. I know that you've dealt with the other part. The part that we're dealing with now, we also need to flight. You can just flight it for us, please.
Okay, if the Secretariat can please flight that and then scroll down. It's difficult for me to read and continue scrolling.
And scrolling, not a problem. Mr. Mkhize, can you step in?
No, noted. I will do so. I'll assist.
Thank you very much.
Thank you for your indulgence, Chair.
Not a problem. We are here to assist and we're here to work together. Mr. Mkhize, we're just waiting for you to flight it, and then Mema Arnold can proceed. Ma'am Arnold, you can proceed so long.
My colleague, can you proceed while, yes.
I'll proceed.
Yes.
Okay.
And you just indicate to Mr. Mkhize on which page are you?
Okay, so I am currently on page of the legal opinion. You would scroll down to page. I've dealt with the recommendations, and you would scroll down to page 5 of the legal opinion.
Noted. Members, just for a while, Mkhize is still proceeding that legal opinion is on our group. You will see is the parliamentary one, just for members also to follow through. But Mkhize should load it as soon as possible. But for the interest of time, I'm going to ask Ms. Andron to proceed, and then we'll just check it from our group there on our WhatsApp group to follow the proceedings.
Thank you, Chair. Through you, Chair. So the issues that we have identified from the previous engagement with the petition is there appears to be two, and the one that is that is pertinent is number one, the perceived disparity in state support. And as I indicated, this relates to the difference between the treatment of South African Airways, which was bailed out, and then as opposed to SAX, which was then placed into liquidation. And number two, the outstanding employee entitlements, which involves claims by former SAX employees relating to unpaid salaries, unemployment insurance benefits, as well as pension benefits. And I think point number two is what the committee is currently engaging with. We have listened to UIF as well as the pension funds adjudicator. Now, Chair, I'd just like to touch on point number one, and this is the perceived disparity in state support with regards to the fact that South African Airways was bailed out whilst SAX was placed into liquidation. Now, Chair, Section 213 of the Constitution provides for the National Revenue Fund, into which all money received by national government must be paid, except money reasonably excluded. Section 213(2) of the Constitution provides that money may be withdrawn from the National Revenue Fund only in terms of an appropriation by an Act of Parliament or as a direct charge against the National Revenue Fund when it is provided for in the Constitution or an act of parliament. Now, Chair, honourable members, we can agree that the financial situation of SAX is it's a complex. It has a complex and interwoven history. But the legislative framework described indicates that any bailout or any further payments by National Treasury would have had to occur prior to liquidation, either through an appropriation act as part of the budget process, or alternatively as a direct charge against the National Revenue Fund when authorized by the Constitution or an act of Parliament. This did not occur. The bailout or any further payments by National Treasury did not occur for a multitude of reasons. And as liquidation has already commenced, and the liquidators have indicated and reported to this committee that liquidation is 90% complete, it does appear that any further payments by National Treasury would not be forthcoming at this stage. But I take it that there is still to be further engagement with National Treasury, and I would leave it for National Treasury to fully ventilate this issue.
Recording stopped.
So when SAX was placed into liquidation,
Just hold on, Mr. Mkhize, just make sure the recording is continuing. You can't stop the recordings. These meetings must be recorded. It's an official meeting of Parliament. Can you just make sure, speak to IT, this meeting should continue to be recorded. You can proceed.
Thank you, Chair. So we had also dealt with the question of unpaid salaries, and this, Honourable Chair and Honourable Members, we start at page 7 of the legal opinion. So when SAX was placed into liquidation, the Companies Act, and this is the old Companies Act number 61 of 1973, and the Insolvency Act regulates the winding up of the insolvency state. Now, Sections 95, we've heard that the former employees are preferent creditors. I just want to briefly touch on the framework. So Sections 95 to Sections 104 of the Insolvency Act provides for the order of preference for payment of creditors. Now, in summary, creditors are paid in the following sequence. We have Section 95, secured creditors. Section 96 would then follow next funeral and deathbed expenses. Section 97 would be the costs of sequestration. Section 98 would be the costs of execution. And then relevant to the matter at hand is Section 98 capital A, which is employees' salaries or wages. And then following that would be Section 99 statutory obligations. And then Section 103 of the Insolvency Act provides for non-preferent claims, also referred to as concurrent creditors. The liquidators in the previous presentation had dealt substantively with this, but we have included in our legal opinion, and I felt it necessary to touch on this. So in terms of Section 98A, subsection 1, the balance of any free residue will be applied by paying to employees the following: salaries or wages for up to 3 months, leave or holiday pay accrued during the year of insolvency or the previous year, other payments due in respect of any other paid absences for up to 3 months before insolvency, and any severance or retrenchment pay due in terms of law, agreement, contract, wage regulating measure, or as a result of termination in terms of Section 38 of the Insolvency Act. Section 98A 1B also covers employer contributions that were due immediately before sequestration and owed by the insolvent in capacity as employer to any pension, provident, medical aid, sick pay, holiday, unemployment, training, or similar scheme or fund. Now, Section 98A, subsection 2, provides that the Minister of Justice may cap or set a determination in respect of the amounts that employees are entitled to in terms of subsection 1. And this determination has been made by the Minister of Justice. And in respect of salaries or wages, the cap is set at 12,000, and that is the maximum that an employee is entitled to. Now, Section 98A3 of the Insolvency Act provides that an employee may still be entitled to salary, wages, leave, or other payments in terms of 98 capital A subsection 1, even though the employee has not proved his or her claim, but the trustee will require an affidavit in support thereof. Section 98 capital A4 provides for a further order of preference in terms of claims referred to in subsection 98(1), Roman numeral I, this refers namely to salaries or wages for up to 3 months, will be preferred over claims referred to in Roman numeral 2, that is leave or holiday pay, Roman numeral 3, that is other pay in respect of paid absences, and Roman numeral 4, that is severance or retrenchment pay due in terms of any law, agreement or contract wage regulating measure. So Section 98, capital A4, caters for situations where there is not enough free residue in the insolvency state, in terms whereof claims will rank then equally and abate in equal proportions if necessary. What does all this mean? In the legal opinion, we explain, and the liquidators have also dealt with this substantively. The payment of former SAX employees' salary claims is governed by Section 98, capital A of the Insolvency Act. The liquidators have advised the committee that each employee is to receive a flat preference dividend of approximately 4,528 rand and 29 cents. While the total amount still available, and this is in respect of the 55 employees which are being traced, or in terms of which the FICA documents are still outstanding, is 248,520 rand. The cap set by the Minister of Justice for claims under Section 98A, 1AI, this is in respect of salaries, is 12,000 rand. So on the liquidators' figures, the free residue, that is what is available in the insolvency state, was insufficient to satisfy the employees' preference claims, and that is why we're seeing a flat preference dividend of approximately 4,528 rand and 29 cents. Chair, honourable members, we note that the report also provides that the pension fund adjudicator is to investigate the non-payment of pension or provident-related benefits to petitioners. Now, I know the pension fund adjudicator has explained their legislative mandate and when claims may be investigated by them. But Chair, in my research, I just wanted to draw the committee's attention to the fact that I note the previous Portfolio Committee on Public Enterprises, as it was in the 6th Parliament, has indicated, and they have reported, that the Financial Sector Conduct Authority appointed a liquidator for the retirement and pension funds of South African Express. Therefore, Chair, it follows that the FSCA, Financial Sector Conduct Authority, together with the appointed liquidator would be able, this is the appointed liquidator of the pension and provident funds, would be able to direct or provide guidance as to any outstanding fund monies that are due. Chair, we don't have any information as to the status quo of the actions that have been taken by the FSCA and the appointed liquidator in respect of the retirement and pension funds. However, from a practical point of view, they would be best suited to provide this direction and an update to this committee. Chair, in respect of the UIF, and my colleagues from the UIF and from the Department of Labour, and the Honourable Minister has briefed us with regards to the UIF. But Chair, we note that SCOPA has indicated that there has been collaboration with the Unemployment Insurance Fund, and back in 2020 there has been submission of documents. So Chair, it would be the liquidators together with the UIF, and they have already provided and advised us as to the outcome and the process that would have to be followed. In conclusion, Chair, any payment of money by National Treasury would be subject to an Appropriation Act or a charge against the National Revenue Fund when authorized by the Constitution or an Act of Parliament. And Chair, we are of the view that any further payments by National Treasury would have occurred prior to liquidation. But as we have indicated, we would leave this point for National Treasury to further ventilate. And Chair, in respect of the pension fund adjudicator, we direct the committee's attention to the fact that the FSCA has been involved in this matter. And then the former SAX employees rank as preference creditors under Section 98A, capital A of the Insolvency Act. And according to the liquidators and according to the mathematical calculation, the amount payable to each employee is approximately 4,520 Rand and 29 cents. There is a cap that was set by the Minister of Justice, And from the calculations and from the liquidator's figures, the free residue appears insufficient to satisfy the employee's preference claims in full. Thank you, Chair. Thank you, honourable members. As I've indicated, I have on the draft report indicated or just included our comments from our office in respect of the recommendations, which range from 7.1 through to 7.7. These recommendations emanate from our legal opinion. Thank you, Chair. Thank you, honourable members, for the indulgence.
Thank you very much, Ms. Mayor Unrod, for that input, comprehensive, and it's really indeed assisting us as a committee to move forward. Honourable members, that was the second last input. This one is internal from our parliamentary legal services. I'm going to hand over to our researcher, who's also going to take this committee through her analysis in terms of this petition. Mr.
Recording
Mkhize,
in progress.
You just guide us who is going to proceed with that research analysis. Again, members, this document has also been circulated in our group, in the WhatsApp group. Mr. Mkhize, guide us. Is it going to be Ms. Mwala who's going to take us through?
Yes, Chair, according to, in terms of research units, Mrs. Umar will take us through.
Thank you very much. Over to you, Ms. Mwala. And then just make sure you can also fly that report to us on the screen, Mr. Mkhize.
Noted, Chair.
Okay, Ms. Mwala, over to you, our committee researcher, who's just going to give us a highlight. You don't have to go word for it, Ms. Mwala. You can just touch on the key items in your presentation. We'll really appreciate that.
With my help, Chair?
Yes.
On my side, I have a technical glitch in flighting. There's something that happened, yeah, but I'm working on it. So currently I can't flight something. Something just happened.
Noted, Mr. Mkhize. Ms. Mwala,
Yes.
over to you.
Good morning, honorable members. Good morning, Chairperson, and good morning to everyone and the stakeholders that are here. I'm going to just go through the research analyst. Are you flighting it?
Ms.
I'm
Mwala,
having a challenge. You can
Ms.
flight
it's
on your
fine.
side. I'm having a challenge on my side currently.
Okay, let me just try.
Then to the honorable members, the document has been circulated. If you can just check on your on the group, that document is there. Whilst Ms. Mwala is flighting the presentation. Over to you, Ms. Mwala.
I'm just trying to flight. I can't flight. Can I just present? Shame. Without.
You can
I'm
proceed.
struggling.
Okay, you can proceed.
Shay, I'm just gonna go to the office. I'm just gonna go straight from the office of the National Treasurer. As the legal team has indicated that if ever the National Treasurer was to sought relief for the sex petition, they would have done it before the liquidation had happened. This is the same, and also okay. So when the SOEs like sex liquidated outstanding salaries become creditors' claim against the estate, Treasurer can only fund this if Parliament approves a specific appropriate or bailout, not as the routine payment. In the South African Express case, the liquidators have indicated that many workers' salary claims may go unpaid because the estate because the state has insufficient assets. Therefore, the role of the National Treasurer must be considered within the framework of the Public Financial Management Act 1999, which requires departments and public entities to manage resources efficiently and accountably. Matters relating to internal financial management and fiscal decision-making fall within the oversight function of the relevant parliamentary committee, which may seek clarification directly from the executive authority responsible. In the present case, the Minister of Transport serves as the executive authority for the South African Express Airways and previously appeared before the committee in December 2025. In addition, the Cabinet is responsible for approving proposal for funding from the fiscal, including those relating to state-owned entities, after which such proposals are considered by Parliament through the appropriate processes. According to the National Treasurer, may be requested to brief the committee on the fiscal and legal consideration relevant to the petition and to assist in identifying the scope of relief that may lawfully and practically be made available to the petitioners. In terms of the pension funds, the airline owed a total of 980 million to its creditors and workers 183 million, which includes 81 million in several packages. Leave pays of 43 million and 59 million in outstanding salaries. A further 150 million is owed to the South African Revenue Services. Out of these 665 claims received, 610 employees have been paid their preferred portion. Meanwhile, outstanding of 55 employees remain unpaid. Because provincial liquidator said they had not been able to trace or failed to provide Financial Intelligence Center Act FICA compliance documentations. The pension fund's role is to safeguard and administer retirement benefits in accordance with the applicable fund rules, stationary requirement, and the liquidation process. Where former South African Express employees alleges non-payment of benefits, the fund administrator, in consultation with the liquidator, where necessary, should verify membership status, confirm contribution reports, calculate the amounts due, and authorize payment only once the relevant legal and administrative requirements have been satisfied. In practical terms, the fund may undertake the following action: verify eligible by confirming whether the individual's concerned was a registered fund member and whether the relevant deductions were made from the remuneration. Secondly, to calculate any outstanding benefit based on the contribution received, applicable interest, tax implications, and any adjustment permitted in law during liquidation. Also process the claim and prepare payment once the liquidation accounts have been finalized and payment is legally authorized, and also assist with the collection of verification of supporting documentation, including employment records, payslip, proof of identity, and other information required to finalize the claim. Relief for unpaid pension funds can also be sought through the Office of the Pension Fund Adjudicator. The Office of the Pension Funds Adjudicator was established in terms of the Pension Funds Act number 24 of 1956 as amended to dispose of pension fund related complaints launched in terms of the Act and complaints designated to the adjudicator in terms of Section 211 of the FSR Act. The main objective of the OPFA is to ensure that the rights of consumers of pension products and services are protected and they are treated fairly within the prescribed of the law. Complaints launched must be disposed of in a procedural, fair, economical, and expeditious matter. Thank you, Chair.
Thank you very much, Ms. Nwala, for that high-level presentation from your report. We really appreciate your time. Honorable members, this concludes then the presentation from our key stakeholders that we've identified. We started first with the Department of Employment and Labor, led by the Minister and the senior officials. We also had an input from the Pensions Funds Adjudications adjudicator. We also received input from the Parliamentary Legal Services as well as our own research unit. Now, this assists us as members of the committee to be able to delve deeper into this petition. I'm now going to open the floor for members to interrogate all four presentations. We are still having those stakeholders with us on the platform, and they will be able to clear any concerns, inputs, or questions that the members will ask. Just an indication, members, I'm looking at the screen for any hands from the honorable members to assist me so that I can note the members who wants to raise their issues. I note Honorable Machobeni. I note Honorable Mananiso. Machobeni. Honorable Mananiso. Honorable Emeki Midupi. I'm noting Honorable Peter Noe. And then those are the only, is it 4? 1, 2, 3, 4 members. Thank you very much. Over to you, Honorable Machobeni. You can proceed. We can somehow introduce ourselves because when I started, we didn't do the introductions. Over to you.
Thank you very much, Honorable Chair. Greetings to you, greetings to honorable members, Minister in absentia, and the delegation and the staff. Honorable Chair, because of a network, the latter speaker, she was cutting off. Maybe I will get something. Sometimes I'm losing in network. But Honorable Speaker, the question that was raised by Honorable Gerike, the issue of the presenter said you can't pay e-complaints more than 3 years. I just want to understand these employees, where they belong to this statement you made concerning can't pay complaints more than 3 years. And also, I just want to understand, he mentioned about 55, they paid 660 something, 55 employees that they didn't receive compensation because they are being traced. I just want to understand what is the solution to get them in order for them to get their compensation. And also, this thing of mine is slap. For now, Chairperson, I'm done for now.
No, thank you very much, Honorable Machobeni. You can still go through your notes. I'm going to give you another bite if you want to have a second bite at the questions. Thank you very much, Honorable Machobeni. I'm going to hand over now to Honorable Mananiso. Over to you, Mananiso.
Thank you, Chairperson, and all members on the call. Chair, let me start by appreciating all the depth of the information received from all our presenters and institutions that have came before us. I think one would want to start by acknowledging that entities like your pension fund adjudicator and as well labor have been involved in this particular process of ensuring that there's fair processes to those who are creditors. And on the other matter, I want to indicate that I'm partly covered by the question of Honorable Machobeni of these 55 outstanding people that needs to be paid, to say what are avenues of tracing them so that at least we can be put abreast if there's something that the entities can do in ensuring that we get to find this outstanding people to be paid, because you would understand maybe there are some reasons why they can be traced. And the other matter that one would want to just ask to your good self as the chairperson is perhaps to write a letter to the Department of Transport in detail, just to get sense on what could have happened with the assets during the liquidation process, and that full details that we want in terms of whether those assets were valuable, in a sense that some were auctioned, and was their money recouped from those particular processes of those asset disposal or what, so that at least we can get sense that where the situation of all those assets are, in which level of value for money or not. So we can conclude with on the issue of the assets. So I would want to just ask you yourself and the secretary to write a letter so the department can then give us details with regards to what could have happened on issues of the assets. So we can close that particular matter, because we can see that on other issues that has to deal with the pension fund, members or those who were supposed to be paid have been paid, beside these ones of 55 people. And I think the work has been done to date with regards to what we recommended as this committee that we wanted to be done, or on other matters, as tabled on 7.1 of our recommendation up until 7.5. So that's what I just wanted to say, Chairperson, with regards to this matter of finding this report for conclusion, so that it can go to the NCOP. So I think most of the work has been covered from the details that we got from today's presentation. Thank you.
Thank you very much, Honorable Mananiso, for that input. Thank you very much for staying consistent with the work of the committee. I noted Honorable Kim Midupi. Over to you, Ma'am Midupi.
Thank you very much, Honorable Chair. Chairperson, let me also join my colleague in terms of welcoming the presentations. However, Chair, mine is not more of a question, but it's a concern having listened to the presentation, especially from the advocate and the Caesar. There was from the presentation that was given to us, clearly there are a number of areas that we need to satisfy ourselves with, particularly on the issue of severance package, whether maybe we need to give the department an opportunity to dig deeper into this matter with regard to the severance package, or maybe payments in terms of all the pension fund benefits in total. So as when we consider the recommendation, either from the researcher side or from Parliament, we should have actually satisfied ourselves that more areas that were of question marks the department still doesn't have in their records. I should think it will only be proper that we also give them more insight to go through. And again, I'm also aligning myself with the recommendations that were presented before us by the parliamentary legal, from the legal opinion by Parliament. I should think prior to that, we should have exhausted all the areas that needs to be, all the loopholes that are there that needs to be locked. So in that case, Chair, that is the comment from my side. It's not a question as such, but I am noting what has been presented to us because it was more informative as well. Thank you very much, Chair.
No, thank you very much, Honorable Midupi, for that inputs. And you are spot on in terms of the case that is still can be explored within this petition, and what there's still a case for the petitioner as well, coming from the Department of Employment and Labor. But thank you very much, Honorable Midupi, for that. I'm going to now note that Honorable Noe, over to you.
Thank you, Chair. Let me also stand on the protocol established and appreciate and welcome the presentations. Indeed, the committee is on the right track in ensuring that we ensure that everything else is brought forward in order to assist the petitioner in this regard. And I want to really appreciate the work that the relevant stakeholders that have been called to assist, the information they have presented. However, Chair, I might have missed, but the Treasury and the Department of Labor, it's like in their presentations, I think they probably left out to make the recommendations as far as their understanding or their area of role is concerned, just like as the pensions has done and our research unit. And therefore, Chair, based on that, for our purpose as the committee in the work that we have been doing and still pursuing this matter to finality, the stakeholders around here, they are our resources to ensure that this matter is brought to finality. We will not be able to do it on our own as a committee. Therefore, Chair, my suggestion based on this information presented to us, rather than interrogating it as it were, though it came late, will it be possible, Chair, therefore, to constitute a committee comprising of all the stakeholders, like you have already made reference to Department of Transport, that they come together and look at all the gray areas as far as this matter, how it has been handled, up to where those outstanding employees had to petition, and make sure that each and every gray area that will be identified, which is detrimental to the employees, having identified it and also recommend a solution to each one of them for each institution, what it should do, as Pensions has said, if there is anywhere, perhaps they could still play a role based on the legislation that guides them, they will be happily do so. So that when it comes back to us again, it comes back to us by all these institutions having dealt with this matter and recommended and having ensured that by the time it goes back to the NCOP, it goes to the NCOP as a final matter of document that this is how this matter will be settled, so that we don't have another back and forth session. Thank you very much.
No, thank you very much, Honorable Noah. You are spot on. And I think maybe it will also form part of the recommendation now emanating from our session from today. And indeed, there is a lot of gray areas that must still be explored. We are noting the point that you have raised. I have also noted the Honorable Gerika from the Economic Freedom Fighters. Over to Honorable Gerika.
Yeah, thank you, Chairperson. And again, good morning to you and to the colleagues and to all these stakeholders. First and foremost, let me say I'm almost there where colleague Noah is, but I will amplify my motivation. But first and foremost, say thank you to the legal advisor of Parliament, having given us a broad explanation or layout of even case law and references that she has made. That was very comprehensive, and I appreciate this. Chairperson, this is a very serious matter, and it involves a lot of other stakeholders, as we've heard this morning, Department of Labor, the pension funds, and so on. And each one has its own legislative framework in which they operate. And it would appear in terms of the presentations that have been submitted here this morning that some of these legislative frameworks are irreconcilable with one another. In other words, for instance, the issue raised by Mr. Essob, if I understand it correctly, says that you cannot go over 3 years, then it has reached the expiry date, if I stand to be corrected. Now, on that point, because this is a complicated matter, and a matter with a historical background where there were neglect from certain institutions and stakeholders and even departments. And I want to go as far to say most probably constituting criminal conduct in this regard, which we have not explored. We're just on the administrative issues at the moment. But the concern is that if it has reached its birth date over 3 years, is there a way that these employees or the organizations can submit an application for condonation to whichever authority, because there are extraordinary circumstances in this petition, Chairperson? That is the first point. And we want a clear-cut answer, because it cannot be just if it has reached 3 years, it expires and there's no benefits or nothing for the people. Somebody has to take responsibility to say that we have neglected this law, this piece of legislation, or this process. This is what I'm trying to say there. Then, because of the complication of this matter, the depth of this matter involving all other parties, and it would appear, and I want to go as far to say it would appear that some parties want to exempt themselves from this process and run away and say, oh, we wash our hands in water and we've got nothing to do with this. We cannot allow this to happen. Parties must and institutions must, stakeholders must take responsibility. And I latch on then in closing to the point of Honorable Nowhere to say, in order to consolidate this process, we cannot just take an ad hoc presentation from this organization, their department, and the other, because they need to get together to map a way in terms of the way forward to the benefits of the employees. Now, taking into consideration and taking seriously note of the point that the legal advisor has made to say that there was a rescue plan for SAA, we must then go and look into that rescue plan to see whether that same format can be applied in the event of SA Express as well. This is in short, Chairperson. There's a lot to say. We cannot do it in 5 minutes, but we need a comprehensive understanding. When all those entities came together, they constitute, they submit their concerns, they say what can be the outcome and what can be applied in order to make the process easier and streamline it on behalf of the employees. I thank you, Chairperson.
Thank you very much, Honorable Gericke, for those inputs. And I couldn't agree more with you. I also was getting a sense when I was going through the documentation, there are those who want to take their hands out of the process. And I think every stakeholder, especially our government, we need to take up and look at what went wrong, what are the avenues that can still be closed. And I'm taking note of the inputs by the honorable members, in particular from Honorable Gericke and Honorable Noah, in terms of more areas to explore. Honorable members, I don't know, is there anyone I'm leaving out? Honorable Nkosi, are you covered? And then Honorable Machobeni, do you want to have a second bite, or are you also covered?
Chair.
I'm covered, Chair.
All right, thank you very much, Honorable Machobeni. Honorable Nkosi, you can proceed. Honorable Nkosi.
Chair, thank you very much, and thanks to the honorable members. Chair, I must indicate I'm really disempowered when received the documents at the 11th hour with this comprehensive. I hope we'll do justice. I'm going to read it through perhaps when we then analyze to finalize our report to the NCOP. I'll be able to make further inputs, but otherwise, I think under the circumstances, that's why I didn't raise any hand, because I felt I'm really disempowered. But anyway, thanks, Chair.
No, thank you very much, Honorable Nonkwanyana, for that. And we take note of the concerns that you've raised. And indeed, when we finalize our report, we will delve through in terms of that. One of the key issues that I picked up before I give the stakeholders to respond, May Unrolled, I'm noting a hand from legal services. I will give you a chance. I took a note of your hand. The issue from the Department of Labor in slide number 13, and maybe if it's possible to share it again, you did indicate there is a case that must be covered, and there's a case for the petitioner. And you spoke about you need time to look at how the proceeds and the payments were made to the former employees. You couldn't confirm immediately in the presentation in terms of was that area closed. And one other thing that is very important, also coming from the pensions adjudicator, is that they wants to determine in terms of the pension fund that the members belong to or the employees belong to, does it fall within their regulatory framework? And I think that's going to be important. But now you'll have to indicate how long will that you will able to take. How long will that take you in terms of verifying which pension fund these employees belong to, and is it covered within your scope? And I think that's one thing that I picked up also from you. So we'll have to look in terms of that area and how can we explore it. And then the big thing that I'm also getting here is that there's going to be work that must be carried out. And if you gather from what the honorable members were saying, that we'll have to, as part of our recommendations, have a specific target for the different departments who must go and explore further in terms of that. And honorable members, if you looked at some of the recommendations in our initial draft report, you will have seen that we had identified a number of stakeholders. We want to widen that scope so that they go and further explore and report to this committee in terms of that work. And that's what I'm gathering from the members, and I'm summarizing it in that fashion. And then, members, just one thing, the issue that came from Treasury, they wrote to my office saying that, they don't have jurisdiction per se on this matter. And I think it's a very important item that members must note. They are pushing the buck back to the Department of Transport and within the ambits of the minister, who's now the executive authority for this entity, or as it was under Howard. And for me, it raises a very, very gray area. Because you'll remember that in our engagements with the Minister of Transport last year, she was putting the bug back at the business rescuers and liquidators, and I'm having serious concerns when we are having a back and forth, and I don't think it's helping this committee and helping those petitioners moving forward. And I couldn't agree more with Honorable Gerke when we're saying, we can't have a situation where there are those who are taking a back seat and saying, they are not part of this, their hands are tied, and so forth. And for me, that's something that we should really, really look into as this committee. Those will be my inputs and my gray areas that I wanted to clarify. And then I'm going to hand over again. We're going to start when we started initial to get those responses, and then we'll conclude and take this matter forward. I'm going to hand over again to Labour, and then they will respond to the issues that members have raised. Any clarity that you want to provide, I'm going to hand over again to the DDG, and then you will take us to those who must respond. Over to you, Memilwa.
Thank you, Chair. I'm going to ask Advocate Msisa to step in and respond to the very specific matter that was raised by Honorable Nkosi around whether the inspectorate conducted any inspections or did any work. If yes, what were the issues? And I think basically that is what was raised specifically in terms of something that we can respond to. And the rest I'll just try and summarize when Advocate has responded. If you allow, Chair, in that order. Thank you.
I allow in that order. Can proceed, Advocate.
Thank you so much, Chairperson. Chairperson, we don't have a record of an inspection of 2020 because our records in terms of the case management system starts from 2021. So we're unable to track if in 2019 or 2020 it was done because our process was still manual then. But also the issues that are raised by members of parliament are taken note of, because I agree that we still have to look at three issues. The first one being the question of the residue, whether how much was the residue and what led to them being the dividend being agreed upon as 4,500 in 2029, based on what was recovered in terms of the residue. We still have to satisfy ourselves along those lines. And secondly, if there was still enough residue for statutory payments. And the last part is to check in terms of the payroll to say how many employees were part of the payroll at the time of liquidation vis-a-vis the 500 that are already disclosed to have been applicants by the unemployment insurance, and taking into consideration also the 55 that could still not have applied for unemployment insurance, those that are still tracked. So we still need to deal with those three issues, and they will have to deal with that within the committee that is set up, working with the Parliament in terms of the legal service of Parliament that has got much more information than we have, and also checking our records and filing them, so that whatever that we come up with a period that will be agreed upon is something that will be more comprehensive to assist this committee in that regard. Thank you so much.
Thank you very much, Advocate. Memula, who's next?
Yes, thank you, Chair. I think Advocate has sort of also covered what I wanted to cover. Issues raised by both Honorable Medupe, Honorable Noe, and yourself, Honorable Mugai, are very specific and pertinent to the matters that you are dealing with. And we agree that in our concluding remarks and our way forward, we sort of emphasized the legal and regulatory framework and things that could possibly be undertaken for the petitioners. And what your comments are helping us with, it's sort of to shape the way forward in a way that is more pragmatic and very specific. We can make a commitment to this committee that at most in 4 weeks' time, we should be able to provide some information regarding very specific matters. I don't want to regurgitate. Advocate Msiza has specifically isolated those cases. So we believe that there is a case to be made. There are investigations that need to take place. And in 4 weeks' time, and all working with all the relevant people, we will be able to provide feedback. That undertaking we can make from the side of the department. Thank you, Chair.
Thank you very much, Memula, for those. This committee also deals with undertakings. So you've made an undertaking. We are going to hold you to it. We do executive undertakings, yes. You've made an undertaking to this committee, and we will definitely take that matter up. Honorable members, that concludes then the responses from the Department of Employment and Labor or their entities. I'm not going to move over to the pensions funds adjudicator, specifically in terms of the period, maybe just to touch on some of the issues that were raised by members, highlight, but you can get a sense that the work is still ongoing, is still continuing. But I just want to give you an opportunity. I don't know, is Mr. Naeem Esop still on the platform? Then he can just respond to some of those key pertinent issues that you picked up from the discussions from the honorable members. Over to you.
Thank you, Chair. Chair, the issues relating to the time barring, I did discuss it in the presentation. So we are a creature of statute. We are established in terms of the Pension Funds Act. And that sets out what our functions are and what our responsibilities are. And which is why I was also pleased with the legal advisor, Ms. Arnold, when she pivoted from her recommendation, which initially said that we should investigate UIF-related issues. We are specifically required to investigate pension fund-related issues. And there's a section in the Act, which is Section 30, capital I, that talks about the time limit for lodging of complaints And it basically cross-references the Prescription Act, which I think the members might be aware of, which applies in the court system. So it's not a hard and fast 3-year period. So we would look at things like when could the complainant have been aware of the issues giving rise to the complaint, or when could they have reasonably been aware? And we would look at various factors in determining whether the 3-year period applies and whether our jurisdiction is ousted in terms of Section 30 capital I of the Pension Funds Act. The legal advisor also mentioned the FSCA, which does have investigative powers and is not limited by the 3-year period. So if there was some malfeasance with the pension fund, that can be investigated by the FSCA irrespective of how long ago that happened. Chair, I just want to impress upon the members, it's not a case of us wanting to run away in terms of jurisdiction and regulatory frameworks, but our decisions have to be legally sound, and if they are not, then they become fallible to review proceedings, which ultimately prejudices the people who are seeking relief at the end. So that is why we are drawing the attention to that. Thank you, Chair. I think on the other issue relating to which pension fund, that we don't have any database that deals with which pension funds they could have belonged to, but we would rely on the petitioners to then provide us with that information. It would normally be reflected on their payslips, the name of the pension fund, or we could make an inquiry at the FSCA. They do have a database of which employees participate in which funds. But like I said, that relates to pension funds that are registered in terms of the Pension Funds Act. Thank you, Chair.
Thank you very much, Mr. Asop, for that input. You still have also a role to play in assisting us. And I know your scope will be just to focus on issues of the pension fund and just to make sure that they fall within the ambit of the Pensions Fund Act. And I think you will then assist so that we have a comprehensive report now from your side, including other state departments who will assist us. But you will be now confined to what you are legally bound to look into. And thank you for those responses. I'm now going to hand over to the legal unit from Parliament, and then we will wrap it up from this item. Thank you very much. Over to you, Ms. Androld.
Thank you, Honourable Chair. Thank you, Honourable Members and colleagues. Chair, Honourable Members, I just wanted to touch on some of the points that were made, specifically with regards to the 55 employees that are still being traced or whose FICA documents are outstanding. Chair, Honourable Members, as we know, the liquidators had briefed us or had briefed the committee fully on this, but my understanding from having followed and watched the previous proceedings is that there is no impediment to pay these 55 individuals. The liquidators are busy tracing these individuals, and should they not be found, their money would then be placed in the Guardians Fund, which is administered by the Master of the High Court. Chair, it goes without saying that I think some of these questions, the liquidators are best placed to answer them, but that is what the liquidators have reported to this committee. And then similarly, with regards to what could have happened to the assets of SAX, now we know that there's still the outstanding matter of the sale of the intellectual property. I think that is at around 150,000 rand. But again, the liquidators, and this information should be reflected in the liquidation and distribution accounts. But I think the liquidators would be pertinent in feeding into the recommendations of this committee. So, Chair, I would just like to touch on I think Honorable Gerike and Honorable Noah had indicated or had sort of framed a recommendation. And as the Honorable members are aware, NCOP Rule 214 does provide that the committee, it provides the powers of the committee once a petition has received, and a committee to which a petition has been referred may, with the permission of the chairperson of the council, refer the subject matter of the petition to the executive of a particular government department or other administrative agency for further attention. Now, just broadly speaking, one of the recommendations that is busy being framed is that the different stakeholders are to come together and provide or input what can further be done to help these petitioners. And the stakeholders, as we can see, is the department, it is UIF, it is the pension fund adjudicator. But I just pause to mention there, insofar as the pension fund adjudicator has indicated that they are a creature of statute and there may be certain limitations with regards to what they can do. I think it's important that further research happens also in respect of the FSCA, who have actually appointed liquidators for the pension and provident fund of SAX. So I think further the research and interrogation with the FSCA is of fundamental importance. Chair, another important stakeholder would be the liquidators of this estate. They essentially possess a wealth of information as to what happened to the assets, the names of the employees, what had transpired, as well as the reporting in terms of the liquidation and distribution account. Chair, honorable members, as I indicated, I had shared with the committee our comments from legal services in respect of the draft report. Now, insofar as the draft report is in a draft form and this needs to be further developed, as Honorable Gerike and Noah has indicated and has sort of given guidance and direction to the committee, I have indicated my inputs on certain points, and I think once the different stakeholders have come together and sort of given their direction as to what can be done, I think research and content, I'm uncertain whether this committee is staffed with a researcher and a content advisor, but there needs to be a sort of an assistance to the committee to frame these recommendations appropriately. Chair, I had noted from the previous engagements by this committee, and a thing that I'm not seeing come through, Chair, in addition to the fact that the FSCA needs to be consulted, or there needs to be further engagement with the FSCA, because there appears to have been done some work in respect of the petitioner's pension fund and retirement funds. And we need to ascertain what exactly happened to those monies. The report, and I understand that the committee had also investigated or had discussed, there was been some discussions around the fact that when SOEs fail, it is essentially the employees who are most disadvantaged. And because the fact that there is compliance with insolvency law does not necessarily equal justice. I remember that the committee had interrogated or had asked the Human Rights Commission whether there had been some sort of interrogation or an application of mind as to, whether there could possibly be some sort of legislative amendments or some sort of, I don't know, it could possibly be some sort of research that needs to happen into the fact that, yes, the insolvency laws are complied with. Yes, the SOE is subject to liquidation, but then what happens to the employees essentially who are suffering economically they are disadvantaged from a socio-economic aspect. And we might not have all the answers as a committee, but it might be a question to pose for further research that needs to happen. And then, Chair, honourable members, I've noted that there was also reckless trading allegations, and I noted that the report in its current form does not deal at all with these reckless trading allegations. Section 417, 418 inquiry had taken place, and there had been some alluding to the fact that the director's conduct, it was found to be grossly negligent. So it might be pertinent that the report interrogates those issues as well. Thank you, Chair. Thank you, honourable members. My apologies if I feel I've spoken a lot, but these are just issues which I think can feed into the report and might assist the research and content advising team of the committee in formulating these recommendations as mandated by the NCOP rules. Thank you, Chair. Thank you, honourable members. Thank you, colleagues. That's all from me.
Thank you very much, Androd, for that. You summarize it very well. And you are guiding now this committee moving forward in terms of how we approach this matter. And there are very, very important areas that you touch. And I think one of the critical point, Honorable Gerike, I've noted your hand. I'm going to give it to you now. One of the key issues that you touch is the vulnerability of the employees. And I think that's where we are trying to close that gap, to say yes, you know, when these companies are put under rescue or they are insolvent and so forth, the employees almost come at the back foot of what needs to happen. And we fail to grasp the point that actually employees are at the engine room. Because when you look at the list of creditors, I think one of the presentations spoke to it that the employees are not listed as priority. They all come there at the back. They will tell us about the other creditors and whoever is owed and who must first be accommodated. But then the employees who are most vulnerable are coming there at the back. And I think there's a gap that we also are trying to close as this committee. I'm noting the hands of Honorable Gerike and Honorable Noe, and then we're going to close this item so we can deal with our other matters. Honorable Gerike and then Honorable Noe. Over to you, Tate Gerike.
Yeah, Chair, thank you. I'm not going to waste time. Want to make a proposal, but let me first say, as men, we sometimes need to celebrate competency of women. And I do celebrate the competency of the legal advisor this morning in giving us a broad perspective of legislation and the law, and even guidance in terms of the NCOP. Chairperson, you've heard that the legal advisor spoke about reckless trading and so on, and I did not want to go there because I did not want to find myself. I have mentioned possible criminal conduct. Now, the committee, I believe the aim of the committee is not to punish certain entities or certain people. However, we need the cooperation of everybody to resolve this matter amicably. And I'm going to agree with you. In all the reports that I've read, it would appear that the employees or the petitioners take a secondary position over above what they asked to ratify for the for the institutions and those that need to be paid and so on and so on. So we need to prioritize the petitioners and the employees that need to be paid so that we do justice as a committee to them. And then lastly, Chairperson, we must then go into a thorough process where there's a meeting of the minds, where people find each other and departments find each other in terms of the way forward. I understand what Mr. Esop is saying, that they are a creature of law. Yes, you are a creature of law, but your involvement in that meeting of the minds will give guidance on most probably other areas that have not been touched, and that you can definitely, your department or your institution can assist this committee. And the proposal will be, Chairperson, that in line with what I've submitted, and I think Honorable Noe also, that we propose a joint committee of all the relevant institutions and parties and stakeholders to map the way forward, to go through this entire process and to come up with a relevant recommendation amicable recommendation in terms of the way forward. Thank you, Chairperson.
Thank you very much, Honorable Gerike, very progressive. And then Honorable Noe, over to you.
Yeah, thank you. Earlier I forgot to indicate, as you can see, what is crossing over my chest. I'm on my way to consult, as you know, my status. I'm going to see the practitioner now, the health practitioner. So I'm stepping out of the road and continue. Chair, it's just a slight one that came out of the legal advice that the wording sometimes might cause problems going forward. I just wanted us to correct the wording that the suggested committee, it's not going to look into what could be done. It's going to finalize what needed, what should have been done, because there shouldn't be any further way forward, like I said, back and forth. Once they meet, they are being charged and mandated with the responsibility as the institutions established by government to deal with such matters. It is within their parameter to finalize it. It cannot go to any other institution except them, because they are mandated by legislation, as it has been said, to conclude this matter, not to go and look for where can it be referred to again. Just wanted to correct that, Chairperson. Thank you very much.
Thank you very much, Honorable Noe. Thank you very much to the honorable members. This is assisting us moving forward with our petitioners. I would just like to also thank all the relevant stakeholders who are with us. What's going to emanate is that as a committee now, we are going to develop our report. And then our report will have those recommendations. Then we take that report, we table it in the NCOP, and Parliament now will instruct those stakeholders to carry the responsibility. And very spot on what Honorable Noah is saying, the wording will be clear. And I think our content advisor, our secretariat, our research, with the assistance and the guidance of our legal department, will assist in framing those recommendations. The wording must be done properly. And that report then will be communicated in the NCOP in Parliament. And it will be now a report of Parliament, and it will instruct those state departments what exactly must be done. And with those words, I want to thank you. Honorable members, we still have an item, but I will release the Department of Labor. I know the minister has already left for the cabinet meeting. I'm also going to release the entity from the Department of Labor, as well as the pensions adjudicators. Thank you very much. We really appreciate your assistance. And then further communication will come now directly from Parliament. Without further ado, we can allow just 5 minutes to leave the platform, and then we will continue with one last item for our meeting. Ms. Amrod, I see your hand is still up. You want to come in there?
Yeah, no, Chair. My apologies. I'm uncertain. Do you require me to still be in the meeting for your further business, or may I also be released?
No, you're also released. But you are still going to assist our unit, because remember now, the committee, we already had a draft report, but as a committee, we took a decision that we want to ventilate some other items, and that's what we've done. Now, that report, what its recommendations, the recommendation will be amended to incorporate what we have done, the exercise. And then that report will then table it in the House, and then whatever is coming from there, based on those recommendations, the work will continue in the background. But now, as a committee, we've gathered the necessary literature for us moving forward. So, Lebanon, thank you very much. You've really assisted this committee, and you are still going to assist our core team. So, thank you very much. You are also released. We will only remain with the members of the committee. And
thank you, Chair.
Thank you very much. Thank you.
Thank you, Chair. 100% Chair. Our office is always available to assist the committees. Bye-bye.
Thank you, Employment and Labor. Thank you, Pensions Adjudicator. And thank you as well as to Ms. Amrod for that. Honorable members, without further ado, I'm going to ask Mr. Mkhize just to fly so long the agenda. I see a lot of people are still leaving, which is fine. Mkhize, fly the agenda for us so that we can deal with the last item, and then we can close this meeting.
I would apologize for the second time. I think someone from the department, in terms of my system, I can't flight anything moving forward. I'm trying to engage with the IT guys, but I believe
okay.
the members, they do have the draft minutes.
All right. No, it's fine, Mr. Nkize. Members, without wasting time, let us go to on that item. On our group, we have one item from the agenda, which is the consideration and adoption of the draft minutes of the 5th of May. Can we just go on that document, honorable members? It's on our WhatsApp group and on emails. It was shared over the weekend. Just indicate for members, are you able to go through the document? It's just a set of minutes.
On my side, I'm trying my best to fly it, Chair.
No, it's fine, Mr. Nkize. It's fine. Honorable members will see from their gadgets. The meeting is dated the 5th of May, 2026. Honorable Piso, do you want to come in there? Or is it the legacy hand?
Yeah, Chair, it's a legacy and my apology. I'll deal with it.
All right. No, it's fine. Honorable members, the minutes is dated 5 May 2026. You will remember that we were meeting, I think it's 2 weeks ago, when we were dealing with this very same issue of this petition. So we just need to consider and adopt those sets of minutes. I'm going to go through them. We had the meeting on the virtual platform. The agenda was the consideration and adoption of the SA Express petition draft report, and also the consideration and adoption of a set of minutes that were dated 17 February and 17 March 2026. In attendance was myself. We had the Honorable Nkosi Nonkonyana as a committee whip. We had Honorable Nowhere. We had Honorable Mananiso. We had Honorable Billy, Honorable Pala, Honorable Zulu, Honorable Midupi, Honorable Kotzel, Honorable Khirika, and Honorable Machobeni. Mr. Mkizi must just correct there. You spelled Machobeni with a P-E at the end. It must be B-E-N-I. It's Machobeni, not Machobeni.
Noted, Chair.
All right. And then from the officials, we had yourself, Mr. Mkize, we had Mr. Nwala, who's our researcher, Ms. Fakir, who is my secretary. We had Mr. Bazia, who's our committee assistant, and Mr. Majosi from Communication Services. Also thereby, Mr. Bazia is committee assistant. So he's an assistant to our committee. Honorable members, item number 4, I did the opening and the welcome. And I acknowledge all the members who are on the platform. Item number 5, we considered and adopted the agenda. Item number 6, we dealt with the draft report, and we had a number of issues that we were actually dealing with today. We wanted legal advice to come on board. We wanted the pensions fund adjudicator to come on board. We wanted further research, and we also wanted to get from Treasury and the Department of Labor, which we have dealt with today. Item number 7, we considered the adoption of the draft minutes of 17 February and 17 March. And then item 7.1, we dealt with the 2 minutes. And then after that, we closed the meeting at 11:15. Those are the sets of minutes of the 5th of May 2026. With those corrections and amendments, can I have a mover for the adoption of those draft minutes? Can I have a mover for the adoption of the minutes?
Chair.
Honorable Nobe, over to you.
With your permission and indulgence, this time let me not show my picture. And also, Chair, because of the condition in which I am, if in those set of minutes, I know I went through them, but something is slipping my mind now. If there are minutes that deals with the visit to Magog or discussion around Magog, Chair, I want to throw something through the window, of course. I don't have a problem with those minutes. I've seen them, they are indeed in order. Chair, Honorable Kherike earlier on posted something of an article by Maverick that relates to our work in Magog. Chair, if there is any way that article can be considered by our researcher and secretary to look into aspects that have been raised there. There are so many institutions that are commented there, which we were never told, which we never aware of. And I would want us that out of the minutes if presented in our way forward regarding that matter, we should consider revisiting that article and somehow map out a way forward that says those institutions that seem to be having an interest, which we did not meet, we should find a way of calling them to the committee before we finalize that matter, because it's like something is brewing that is going to start all over again and jeopardize the communities. Thank you, Chief.
No, thank you very much, Honorable Nobe. Thank you for the move for the sets of minutes. This is a separate matter, I understand. And indeed, you are spot on. The issue of that petition, I saw that article, but remember what we had, we at that meeting what we had at Magog, we had mandated those state departments to look at a lot of those aspects. So technically, we have now dealt with the Magog petition. Us is just to follow through on items going forward. And indeed, what you are saying is assisting us to maybe also include the Secretariat as part of our continuous engagement. Because remember, the issue that we're having, and I think we've adopted that approach to say, once we deal with the petition, we're not just doing with it and then we throw it out and we say we are finalized with doing. What we are doing, we're doing a continuous evaluation of our recommendations to follow things through. So you are in line to say that you must also, as part of our continuous engagements, we should then look at some of those issues moving forward. But technically, it's not part of the agenda, but it's a work that we have done as a committee, and there's nothing stopping us to look in terms of those aspects that were raised in that article. And I concur with you that we should also follow up as part of our continuous oversight on the matter of Magog petition. Honorable members, Honorable Noah has moved for the adoption of the minutes. Is there a seconder before we close the session? A seconder to Honorable Noah's move.
I second, Chairperson.
Thank you very much, Honorable Klerika. Thank you for that move. Honorable members, then these items have been concluded. There's this item that I think I will bring, but I will just bring it in terms of our official in our next meeting. There's been some move. You know that as a committee, we're not fully having a staff complement. Honorable Mananiso will back me up in this one, and Honorable Pala, because they serve in that structure of chairpersons. I was raising this issue of our content advisor for a very, very long time. You know that we had a person of Mr. Palani Simelan who was with us. Due to contractual issues, he could not move with us anymore. So Parliament has made a move. There's been an appointment in that vacancy. So the Petitions Committee has now been given and felt that position of content advisor. So it will strengthen our work. It will make us sure that even when we deal with these matters, all areas are closed. We don't have any gaps moving forward. So it's an additional resource to this committee moving forward. But in our next meeting, I will officially then introduce the official. I want to follow the protocol of Parliament established. It has come to me informally, but I think it's only fair if it's communicated to me formally, and then I bring the item to the main management committee, and we bring it over to the committee. But at least those areas have been closed, and now we have a full complement of our staff establishment. I just think on a lighter note, as we close this meeting, that there is that work. Don't think that we're not fighting. We're fighting these battles behind closed and behind the scenes, and eventually we are seeing the fruits. Some of these are bearing fruits. Honorable members, with that waste of time, it's exactly 12:30. We are well within our time allocation, but we have exhausted all our items. I don't know if there's any other thing from members. If not, I'm going to close this meeting. Honorable members, is there anything from your side? Something pressing? My apologies. If not, thank you very much, honorable members. Then this concludes the business of the day for this committee. The meeting is adjourned. Thank you very much.
Thank you, Chair. Thank you, honorable members. Goodbye.
Thank you, Chair.
Recording
Chair
stopped.
and members.